the landlord and tenant relationship. This is a presentation that I put together along with Jacqueline Nagel, who's another attorney at our office. Jackie can't be here today, so she asked me to take over on her portion of it as well. Her portion is the first part of it. So if I go over that a little quickly, it's because I'm just letting you know what Jackie's notes say. But she did the first part because she does a lot of transactional work at our office. She does a lot of lease formation and drafting, as well as other types of business formation. And so she really sees clients at the beginning of a lease relationship when landlords and tenants are first getting together. I do the other end of it when the lease is ending and something has gone wrong. Obviously, if a lease ends amicably, there's not probably a need for an attorney to be involved. But if there's an eviction or other problem at the end of the lease, that's when I get involved. And so that's my area. So part one, Jackie's part, the beginning of the landlord-tenant relationship. So we're going to look at residential lease agreements, deposit, renter's insurance, and inspections. These are some of the key topics that she goes over with clients when they come in and ask her for her assistance in drafting a lease. Usually she's going to be working obviously with the landlord, but if you are a tenant in any type of situation, these would also be things that you should be aware of in before signing a lease, or if you're talking with your landlord about the terms of your lease. Now, in general, in Pennsylvania, the statute that we're going to refer back to when looking at landlord-tenant issues is the Landlord-Tenant Act of 1951. This establishes the basic rules, and it provides a lot of protections from tenants, but it's also been updated over time and provides a lot of protections now for landlords as well in terms of setting out the specific steps that they need to take in certain types of situations. So, for example, it explains what a landlord does if a tenant vacates a property and leaves personal possessions behind. But this is the starting point, and then, of course, there are cases that help us develop the statute meaning. So when there are some basic things that you want to make sure you include in any residential lease. Obviously, you want to name the parties. Who is the landlord and who is the tenant? This isn't necessarily as straightforward as you might think. Who is going to be on the lease as the party responsible for payment can be different than who's allowed to reside in the home. They might be simply a separate resident. They might still need to be evicted though. The landlord also, you need to make sure is the correct party. Is it a management company? Is it an individual? Obviously, as the landlord, you should know who that is. But again, sometimes landlords aren't sure which entity should be named in their lease. You should also state which building or which unit is the lease is for. It should be very specific. So you can't just say an apartment at such and such a street and you have 100 apartments in that complex. It needs to be very specific as to which unit you're referring to. You want to make sure you have the lease term and the renewal terms. That's how long the lease is valid for. Generally, what we see is that a lease is the first term is going to be for a year, and then the renewal term will either be for a year again, or it will default to month. So, and that is what the law says too, that in the event that there is no term at the conclusion of the initial term, then it's going to be month to month going forward. And then, of course, you want to have the rental amount. So those 6 things are the very basic beginnings of a lease. The more specifics, though. So how much? So the lease is usually going to also include a security deposit. I don't think I've really ever run across a lease without a security deposit as part of it. But there are some restrictions on how much of a security deposit the landlord can ask for or require, and what the landlord can do with that money once the landlord has received it. And that goes back to those tenants' rights that are part of the Landlord-Tenant Act. So at no point can a landlord ask for more than 2 months' rent as a security deposit. The security deposit is going to be separate from first and last month's rent. So Often a landlord's going to require first month and last month's rent, and then additionally a security deposit. And the security deposit itself cannot be more than 2 months rent for the first year of the lease. At the beginning of the second year of the lease, you can only ask for 1 month rent security deposit. So if rent is $1,000 a month, for the first year, you can have a security deposit of $2,000. For the second year and thereafter, you can only have $1,000, which means that $1,000 would need to be returned to the tenant at the beginning of that second year of the lease. And that is then for the duration of the lease. Additionally, maybe this is on the next slide. Yes. What the law states, and I know a lot of people don't follow this, but it is very clearly stated in the law and can be a problem later on if the wrong chain of events occur. The security deposit is supposed to be held in an escrow account. It says at an institution regulated by the Federal Reserve Board, etc. So at a bank. And you have to tell the tenant, and this is in the lease, it should say, all security deposits will be held at such and such a bank. So the tenant has a right to know where their security deposit is being held. We're going to talk about security deposits in my portion of the presentation as well, but this is because the conceptual idea of the security deposit is that it does not belong to the landlord until certain events have occurred. So that security deposit, even though the tenant doesn't have it, it doesn't belong to the landlord whatsoever during the term of the lease. And so that's why the tenant has a right to know where the security deposit is being held. Additionally, the security deposit is supposed to be held in an interest-bearing account, and the tenant has the right to the interest on that account if it's held in for more than 2 years. So if you've a tenant for 5 years, for years 3, 4, and 5.
Friday was successfully verified. Goodbye.
So for years 3, 4, and 5, the tenant is owed interest on their security deposit. In practice, for residential leases, this is going to be like $1.50, and I've never seen anyone get too worked up about it, but that is what the law says. Oh, and you are allowed to you are allowed to keep as the landlord like administrative costs. So, again, if the interest is $1.50 and you have a fee on the bank account, that's probably going to eat up any of that interest. All right, another thing that we like to advise our landlord clients to do, because again, it's usually the landlords that are having the lease drafted, is to ensure that the lease states that the tenant must obtain renter's insurance with liability coverage, and that the landlord should be named as an additional insured. This is just for very obvious reasons. If something happens on the property or to the property, we want to make sure that the landlord is protected and is not losing their investment. We also do require that, in I think all leases that Jackie does, she requires that proof of insurance is provided to the landlord prior to move-in or at move-in, and then annually. Again, that is just for the protection of the landlord and their investment in this piece of real estate. It can also, though, become important later on in terms of an eviction, and I'll touch on that later. Okay, so another important conceptual thing to remember as landlord is, okay, the security deposit isn't yours, but you also don't have an automatic right to enter the property after you've leased it to someone else. Once you've leased the property to someone else, it's their property for the term of the lease, provided that the other conditions of the lease are being met. And that's kind of like the very old common law back to England. That's been the law of the land, the law of England, the law of the United States. You learn it first year of property in law school. But the law has evolved somewhat and has recognized that in most cases, landlord's going to need to have some access to the property to do general repairs. The landlord needs to do some maintenance or upkeep on the property, especially in residential leases. Commercial leases, a lot of times the tenant will be responsible for that, but in residential leases, the landlord's going to need to get in there to, I don't know, fix the plumbing or whatever it is. There's no specified time in the act that the landlord must give notice, but the landlord does need to give reasonable notice to the tenant prior to entering the property. A reasonable amount of time is 24 hours. So that's usually what we'll put in unless there's some other discussion between the landlord and the tenant. Landlord's going to give at least 24 hours notice prior to entering the property for any reason. We also like to specify the reasons why the landlord may enter the property. So for making repairs, and this comes up more than you would think, to show the premises to prospective purchasers or tenants. That you might not think, if you're a landlord, you might think, I'm never going to sell this building. And then something happens and you want to sell it and you have an uncooperative tenant in the building. If you don't have a clause in the lease that says you can enter, it's going to be difficult to show that building to prospective purchasers. Okay, this is probably, well, actually it's not that important, but this is a big thing that we always make sure is in every lease. If you need to evict someone, or for some reason, the law specifies how much notice you have to give before you can start the eviction proceedings. And however, the law says that you can waive that notice. We're going to talk about this more in my section. It's not that long of a notice period. It's about 10 days. It's 10 days for failure to pay rent. But because of kind of the level of detail and the manner of service and a number of other things, it's easy to trip up and do the notice wrong and then have to start over again. So it's easier just to have it state in the lease that the tenant is going to waive all notices, and that's very, very common waiver language in leases in Pennsylvania because you're allowed to waive it. All right. So this is not required under the law, move in and move out inspection reports. But what we've seen over time, and I think, again, this goes to common sense to some extent as well, is that everything's great as long as landlord and tenant are getting along. But as soon as something breaks down in that relationship, there's no longer going to be any agreement on, oh, that wall was scratched when I moved in. No, it wasn't. That must have been your damage. Oh, the oven was always missing one of the grates that goes in it. No, it was there when you moved in. No one's going to agree on those items anymore. One way to try to at least make it easier to resolve those differences is if you have both a move-in and a move-out walkthrough together and a list that you sign that accounts for all of those little things. It can feel rather petty, but it does smooth the way later on if either you're the tenant and you're trying to get your security deposit back, and you can have something to point to say, no, see, we both initialed here where it said that there was a stain on the carpet in the living room. Or if you're the landlord and you're trying to keep the security deposit, and you can point to the list and say, see, there's nothing notated here about the carpet in the living room. So again, hopefully you never need this. And so I think people often, as in any relationship that you have with any other person, starts out friendly and you think, well, this isn't ever going to be an issue. It's never going to be an issue until it's an issue. So we recommend that you do both a move in and a move out walkthrough. Sometimes it's easier to get someone to do the move in than the move out. If something's broken down in the relationship, it's not going to be as easy to get them to do the move out walkthrough. But if you at least have that move in list, that can be helpful. Again, for both parties. So Jackie wanted me to remind you that these provisions are just a snippet. Even residential leases can be 6 or 7 pages long, and that there are a lot of other provisions to consider when preparing or reviewing a lease. If you're a landlord, certainly I think it makes sense to talk to an attorney about what provisions you want to include in a lease, especially if you have multiple properties. One lease, you know, I see landlords come in on my side of things with leases that they got from Kinko's. I don't even know if Kinko's is available anymore, that they downloaded off the internet. They might not be tailored for Pennsylvania law. They might not have that waiver of notice provision in there, which really can trip you up when you're going to do something. They might not have other important provisions in there. You might not be aware that you need to escrow your security deposit. Tenant gets a lawyer and they really make a big deal of that. That's great. So I think it's important to have a lease reviewed by an attorney. Tenants, similarly, if you can, I would suggest that you have a lease reviewed by an attorney before signing. I know that's not often the situation. You're often presented with the lease and told, okay, sign it or you don't get the apartment. But it's important to know what you're signing. Are you waiving notice in the event of an eviction? That's probably going to be in most leases that you're presented, but you should know whether or not you are waiving it. And so that you know what your rights are if the relationship breaks down. All right, I'll just pause for a second and ask whether there are any questions before I move on to the next section. All right. Oh, Jackie's got her contact information there on the screen as well. And like I said, she's one of our transactional attorneys. All right, part 2. This is where I come in, the end of the landlord-tenant relationship. So talking about first, hopefully you don't need an attorney, but there still might be some things you need to know. So this is if the relationship ends amicably. We're going to also touch on returning the security deposit or not returning it. It's not quite that straightforward. And then we're going to touch on evictions. Okay, so if everyone's getting along, but the lease is over, or there's another reason why the lease is gonna, maybe now we're month to month and somebody's got a new job and they need to move, whatever it is, it's pretty straightforward in terms of what happens. Either party, either the landlord or the tenant, gives the amount of time required under the lease for notice. It's generally not going to be less than 30 days. And then the tenant moves out. Actually, it's never going to be less than 30 days. 30 days actually isn't that long for the tenant. So it's, again, for tenants, something to look at in your lease. How long is that termination period? If you're on month to month, is there can you ask the landlord for a longer termination period? That might be something that they might be willing to work with you on. Because 30 days really isn't that long if you're having to find a new place to live. All right. Okay, so even though everything was hunky-dory, there can still be a couple issues. There can be possessions that are left behind, and now the landlord has the property, but there's still a couch in the living room. What's the landlord supposed to do with the couch? And there could be damage to the property. Now I skipped ahead a bunch of time. All right. All right. So if the possessions are left behind, the landlord, there's a multi-step process that the landlord has to go through, but it is laid out in the law, which is helpful. Essentially, the landlord has to give notice to the tenant that they have these things. And after the notice period is over, the landlord can then put them in storage and charge the tenant, and the landlord can dispose of them. But there is a specific notice portion of that has to occur first. If there's damage to the property, that's where the security deposit comes in. This is the time when the landlord convert that security deposit from being money that belongs to the tenant, but that the landlord is holding, into belonging to the landlord. So now it's just sitting in that escrow account, and this is where the landlord can actually collect that money. First, the landlord has to send a list of the damages to the tenant. So you have 30 days to do this, and if the list isn't sent, then you can't keep it. So from 30 days from when the tenant moves out until 30 days have passed, you have to go, as a landlord, you have to go into the property, you have to catalog the damage, and you have to be very specific. You have to say the carpet here in the front living room, in the right front corner, had a tear and a rip, and in the left front corner was stained. Cost to replace, and then you give the cost. Or, unreasonable number of nail holes and markings on the walls, cost for apartment to be repainted, X amount of money. And you really need to be dollar and cent specific. This can cost, this can require quite a bit of legwork to get those amounts and put them in the letter. But if a tenant decides to litigate this or dispute this, the case law is incredibly clear that unless the letter is hyper specific, again, to the dollar amount, what each cost is, then the tenant will prevail. So first, send the letter. Second, if there are any excess funds, that in my experience this is rare, but if you need to window pane, and I need to do this, and it's going to cost me $800 to do that. But the security deposit was $200 or $1,000, and you'll have $200 remaining. And the letter detailing the damage to the leased property has to be accompanied by that extra $200. If you've done that and the tenant hasn't disputed anything, then you get to keep the money, the security deposit. And that's pretty much the end of the story unless the tenant decides to sue you. Great. If you don't send the letter, you can't withhold the deposit or do the entire deposit back, and you can't bring a suit for damages. So if you don't send that letter within 30 days, even if you send it on day 35, you're outside of the 30-day window. Now you're no longer allowed to get the security deposit. And if instead of $1,000 worth of damage, it was $10,000, you also forfeited your right to sue the tenant for that $9,000 in extra damages to the property. So it's very important that the damages letter be sent within the first 30 days. You also become liable for double, gets complex, but essentially if the security deposit is $1,000 and there was, again, $800 of damage, $800 in damage, you are liable then to return for double the amount of the excess, meaning $200 times 2, so $400 in additional damages to the tenant. So there's some pretty severe penalties to the landlord if they fail to return the security deposit and they fail to provide notice to the tenant that they plan to do so. However, all of that is waived if the tenant does not provide you with a forwarding address. So if there is and this happens, there's a bad relationship and the tenant just leaves and you have no way to get in touch with them, then you are excused from sending the letter. But if the tenant has provided you with a written forwarding address, then you need to send a letter. Okay, so now returning back to the requirement. So the law says that the general rule is that you have to tell the tenant before you can file an eviction proceeding. You have to tell them the reason for the eviction, so whether it's failure to pay rent or there's a different provision of the of the lease that is being violated, or if it's because you had the lease is done and they've failed to vacate the property, whatever it is, you have to give them a notice in advance. It has to be personally served or posted. Personal service means it was handed to them personally. It's generally not sufficient actually to mail it to them, even if it's certified mail. So you want to have a constable take it out and serve it to them, or you can take it and you can post it, meaning you tape it to their front door essentially. Tape it to their front door and take a picture so that you can show that you did that. You have to, again, say the reason why, say the required time to surrender the property. And there's kind of some different time frames depending on whether it's failure to pay rent or failure to conform to a different part of the lease. But the most common one is failure to pay rent, and that's a 10-day notice. Again, this notice can be waived. If you're a tenant, look at your lease and see whether you waived that notice. If you're a landlord, when you draft the lease, put that notice in because, again, there's a couple different ways to trip up here. Just emailing someone and telling them, just sending it in the regular mail, like that's not going to be sufficient, and that can be enough to get your eviction case tossed out when you go to the MDJ. Okay, so what's the timeline look like? How quickly can someone be evicted? Well, let's assume that you do have to do a notice. So the first part is you post the notice or you have it served on them. You then have to wait the notice period. So it's safe for failure to pay rent. You wait 10 days. At the completion of the 10 days, so on day 11, you can file the complaint at the MDJ's office. The hearing is going to be another 1 to 2 weeks afterwards. It can't be more than 2 weeks afterwards. So now you are at about 25 days approximately. The tenant is allowed to bring a counterclaim. This does happen sometimes. It's generally going to be for something like the pipes were always frozen, there were mice in the house, something to do with the apartment not being habitable. Even though it might be scheduled then initially for that 25-day mark, it can get rescheduled if, for example, the tenant gets counsel and that attorney isn't available that day. The landlord could also have a conflict and get it scheduled out, so sometimes it does get pushed a bit further. After the hearing, the MDJ, the judge, has to render an opinion within 3 days. Usually it's immediate, but sometimes it does take them an extra day or two. You then have to wait another 10 days, and this is the appeal period for the tenant or the landlord, I suppose. So there's a 10-day appeal period where they can appeal the case to the Court of Common Pleas. So assuming there wasn't a rescheduling conflict, that gets you to about 35 days. And then on the 11th day, you can go and get the order of possession. Yeah, you can go and get the order of possession, and then the eviction gets scheduled by the sheriff. So if everything goes to plan, an eviction can usually be accomplished in a relatively quick period of time. Most civil actions do not proceed this quickly, but you're really looking at 6 weeks to 2 months. Just a note, actually looking back at this on the appeal period, if they do appeal to the Court of Tenancy, what that means is that, so our work is primarily in Cumberland County, so the courthouse is here in Carlisle. They would file an appeal at the courthouse here in Carlisle, and they would be able to stay the eviction until the appeal is heard. That can take a lot longer. However, they have to pay in the rent to the courthouse. So most evictions are for failure to pay rent. And the reason people usually fail to pay rent is because they don't have rent. And the only way to do the appeal is to pay the rent to the court instead of to the landlord. If there is a grace period for the first month, so they can make the first month's payment to the court in 2 pieces. After that, they have to pay the full amount on the first day of every month to the prothonotary. If they miss that, then the appeal is stricken. Not automatically, you have to file something, but the appeal will be stricken, and then the eviction can proceed on the lower court's judgment. So, pay and stay orders. The law in Pennsylvania allows the MDJ, so the Magisterial District Justice, who they handle pretty much all of the evictions. It allows them 2 options. They can either enter a judgment for possession and for monetary damages, meaning that the landlord gets the property back, that's the possession piece, and then the monetary damages would be the amount of rent owed. So they can either order that order, or they can order possession, but it can be what is called a pay and stay order, meaning that if at any time up through the time that the sheriff physically comes to the property to evict them, if at any point during that process they pay the amount that they owe, they can stay in the property. And if they miss the next month, you just have to start over again. This is very great security measure for tenants. So if they're 15 days behind, you go through the whole thing, and all of a sudden they have their probably 2 months rent now. They borrowed it from someone. They can pay that. The eviction gets stayed, and if they miss the next month because they weren't able to borrow the money from someone, you have to start the whole process over again. It's a great protection for tenants. It makes things difficult for landlords who have multiple or repeat offenders in terms of not paying rent. The way to not get a pay and stay order is to have a violation of the lease that is separate from the failure to pay rent. So pay and stay orders can only be entered if the only violation is failure to pay rent. So you want to go carefully through that lease. Again, if you're the landlord or you're the tenant, make sure you're doing everything that's in there and not leaving them any grounds to evict you. If you're the landlord, make sure they're doing everything in there. If there is a provision in there that they're not following, that'll probably be sufficient to avoid a pay and stay order, because again, pay and stay orders often result in repeat delinquencies. One example of that is going back to that renter's insurance provision. So this is something I actually used in the past to avoid a pay and stay order. So the lease says that the tenant needs to have renter's insurance. The landlord needs to be named as the additional insured, and they have to provide proof thereof to the landlord. They never have. That's a violation of the lease that is separate from a pay and stay order. And some MDJs will say that's enough. You haven't paid your rent and you haven't fulfilled that. I'm not doing a pay and stay. I'm just evicting you. All right, collecting on the judgment. So if you're the landlord and someone hasn't paid rent for a few months, you're gonna get possession. again, hopefully not paying today, but you're going to get possession and you're going to get a monetary award for the back rent that's owed. So $5,000 or whatever it is. That's great. What do you do with it? How do you actually pay you $5,000? It doesn't, they're not usually just going to write you a check. For landlord-tenant matters, wage attachment is permitted. Now, there's a whole process you have to go through to do that, but it is laid out, do this, do this, do this, do this. And it's one of the very few areas actually in Pennsylvania law that allows wage attachment for civil judgment. That means that you can, once you've gone through this process, their employer will be required to withhold a certain amount every month of their income and give it to you instead of them. You can think of that as similar to the child support system, for example. It's not ever going to be the whole lump sum. There are still lots of protections for the tenant to make sure that they're still getting a decent portion of their income, but you will over time be able to recoup those costs. Oh, it's on here. Up to 10% of the tenant's net income, as long as it's not putting them below the poverty level. You do have to satisfy this before, meaning you have to go back to the court and tell them that the full amount has been paid within 30 days of the final payment, or there's some sanctions, because it obviously is not great if you don't do that and then you continue to receive those funds every month. You can also enforce this as you would any other monetary judgment. The way we're going to do that is try and get their bank accounts, try and collect against vehicles, real property. There are various problems with all of those methods. So the wage attachment is a really nice tool that's available to landlords that is not available to other collectors. The thing that all of these things have in common, though, is that if you don't have information about the person, it's very difficult to collect. If you don't know where they went, if you don't know where they work, if you don't know what bank they use, you can't get any of their things. And that does become a barrier to collection. It's very helpful to landlords if they know where their tenants work. And that is something that some landlords know and some don't. Again, if you don't have that information, it becomes very difficult to actually collect that money. And some people don't care. Some people say, you know what, they're out, that's all I care about. But if you do want to eventually have that money, then that knowledge of who the tenant is becomes important. All right, says I have a conclusion. All right, well, in conclusion, I think most landlord tenant matters end amicably. I only get involved when they don't end amicably. So a tenant comes and says, hey, I got this notice, the lease isn't up. A very common scenario is that the property was sold and the new owner doesn't believe they have to follow the lease of the prior owner. Not typically the case. Or landlord comes in, hey, this guy is chronically behind on rent, what can I do? That's when I become involved. Or there was, there was $10,000 worth of damage to the property. How can we collect on that? What's that collection piece going to look like? How difficult is that going to be? That's again where I become involved. If you have any questions, you can certainly contact me. I do a fair bit of landlord-tenant work, and I'd be happy to talk to you regardless of which side of the issue you are on. Are there any questions? I don't see any in the chat. And I would like to give everyone a few minutes if they have anything they'd like to talk about. We focus mostly on landlord, I'm sorry. We focus mostly, obviously, on residential leases today. Two caveats to that. Commercial leases have a lot of the same provisions, obviously are frequently more specific and will specify, for example, that the tenant is going to be responsible for all maintenance on the building, or that they're allowed to construct walls. And if you think of a commercial space, the tenant often does a lot of interior construction on it. So commercial leases are different in that regard, but a lot of the other provisions are the same. An important provision in commercial leases that I think sometimes tenants overlook is how long is that termination period. It is usually longer in a commercial lease. It might be 60 days or 90 days. A lot of times that's not enough for a commercial tenant to actually move and find another suitable commercial space. So that's something commercial tenants really should bear in mind. If something happens and somebody offered to buy the building from your landlord, but the landlord has to get rid of the tenants first because the new buyer is going to develop the property, and you only have a 90-day termination period on your lease, is that going to be enough time for you to find a new commercial space and move your entire business? That's an issue that comes up relatively frequently. The other caveat is that mobile home parks are completely separate than any other residential lease. There are a lot more protections for the tenants in a mobile home park than there are for tenants in a regular apartment or a house. I'm not clear on the 1% that the landlord can retain as an administrative fee. If the landlord earns less than 1% from the bank, we haven't paid the tenant interest. Is that correct? Yeah. So that's where, again, that interest piece often doesn't become important because most bank accounts are not paying enough that it would really rise to that level. But it is what the law says. So I wanted to touch on it, that if for some reason you are in a really high interest bearing account with the escrow amount, then you're only allowed to take the administrative fee back, but the remainder of the interest is due to the tenant after 2 years, not before 2 years. And so mobile homes have a lot more protections for the tenant. It can be really difficult to actually evict tenants in mobile home parks because they own the mobile home and they're just renting the property, and because of that, the law has allocated them a lot of extra protections, including differences from normal landlord-tenant law, such as the notice. So you can't waive the notice in the mobile home park. You have to serve it. You cannot personally serve it. So the regular tenant in an apartment, you're going to post it on the door or you're going to have the constable give it to them. That's not what you can do for mobile homes. You actually have to mail it to them certified, and if you don't, you can't evict them at all. So there are some really special nuances for mobile home parks, and if you are a tenant of one, there are a lot of protections for you, and I think you should, if you're facing an eviction, certainly talk to an attorney, because there probably is something that you can do to at least delay the eviction. And if you're thinking about owning a mobile home park, I would also talk to an attorney ahead of time to make sure you understand the difficulties that can arise regarding that. All right, any other questions? Okay. Well, I really appreciate everyone being here today. If you do have other questions, feel free to contact me or Jackie. Our information is available on our website as well. If you didn't get a chance to write down our contact information, and you didn't see it, oh, sorry, I just saw the one about I just saw the question about the fee. I didn't see the other one. Does the landlord have to give more than 10 days to notice to quit during winter months for mobile home parks, but not normal residential leases? So for mobile home parks, it depends on whether it's winter or summer. It changes the length of the notice period, but not for a regular home or apartment. Obviously, I think the utilities have special rules during the winter months as well, but that notice period does not change. All right, again, thank you everyone for attending. Feel free to reach out to us for a consultation if you have any issues that arise. But I wish you the good rest of the evening, and I'll hopefully meet some of you in person at some point soon.